Today on Legalese, we are talking about Trump's big, beautiful bill and the big, not so beautiful threat that it poses to your constitutionally protected fundamental rights. Hey, greetings everybody, and welcome back once again to Legalese. As always, I am your host, Bob, and I want to thank you all so much for joining me here today. If you happen to be new to my channel, let me especially welcome you. This is a podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. Now, let me just remind you guys real quick if you want to find out more about the show or get updates whenever I post new content, you can go to legaleshow.com where you can find all of my videos, articles, podcast episodes, and where you can subscribe to our newsletter and get updates when I post new content. Now, I know it's been a few months since I've posted a video, and so I appreciate your guys' patience and hanging on with me. I am going to be getting back to posting here more regularly, so you can look forward to that. And so let's just ease back into it here today with a fairly short video that I have. And what I want to talk about today is something that anyone who has been paying attention to the news lately has surely already heard all about. These are those three Bs that absolutely everybody all across the country cannot seem to stop talking about.
More booze, more bullshit, more butt fucking.
Sure, the three Bs.
No, 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 no. No, not those three Bs. These three Bs.
Tonight, new battle lines over what President Trump calls his big, beautiful bill.
All right, America, let's talk one big, beautiful bill.
So President Trump, his goal in the Senate was to make the big, beautiful bill even better.
His big, beautiful bill.
Advancing President Trump's so-called big, beautiful bill.
The big and not very beautiful bill.
We're going to have a bill, the one big, beautiful bill. I think it's going to be, it's the biggest bill ever passed.
I do love the way the guy who embodies the modern conservative movement in America brags about how this is the biggest bill ever passed, as though that's a good thing. But of course, as we all know, conservatism stopped meaning small government a long time ago, though I must admit, if I'm being entirely candid here, that somehow it always still shocks me a little bit when that sad truth crosses my mind. However, I want to point out, as longtime viewers of this channel will know, that this channel is not mainly a political channel, and I want to be very clear that this video is not a political debate over the merits and or problems of this bill as a matter of policy. Here, we discuss matters of constitutional law from a legal perspective, helping to break down the legalese of court cases, regulations, and in this case, legislation to help make the information accessible and useful to lawyers and non-lawyers alike. So, to get right down to it here, the plain truth is that there is a provision in this bill which is patently unconstitutional and which stands as an affront to the function of Article 3 courts in service of our civil liberties. Because this provision will rob each and every one of us of our fundamental right to due process of law. Now, this is a provision that has been inserted into the Senate GOP version of Trump's big, beautiful bill that would, if enacted, pose a serious threat to our federal court's ability to protect your constitutional rights. And it does so by requiring litigants seeking a preliminary injunction against a federal government policy to post a potentially enormous bond. Now, Arizona Supreme Court Justice Clint Bullock has an excellent article out, which I will link to in full on the show notes page. And this article outlines the danger this provision poses, and I just want to read a selection from it here. So he talks about how the Senate bill targets temporary restraining orders and preliminary injunctions. He points out that these are rulings that demand that the government halt the enforcement or implementation of a policy immediately, pending the final outcome of the case if a judge concludes that it is likely the plaintiffs will prevail against the government in the end. Now, he poses a hypothetical. He says, just imagine, for instance, that during COVID, courts could not stop executive orders that closed down houses of worship unless millions of dollars were posted in bonds, or as were tried to be passed by some governors, executive orders confiscating guns. Now, the basic idea of a temporary restraining order or preliminary injunction, he points out, is to prevent the damage to the rights and well-beings of citizens from a government carrying out an action or policy that is likely to be found illegal or unconstitutional. He goes on to say how the new Senate version turns that logic on its head, instead seeking to protect the government from any costs that might be incurred from a citizen merely asserting their rights. And this new version no longer tries to take away the power to enforce rulings through contempt, nor does it apply retroactively, which I believe an old version of the House did. Now, that alone would have caused chaos and brought settlements in many old cases into doubt, and it would have imposed a requirement that the plaintiff suing the federal government post a bond in an amount proper to pay the costs and damages sustained by the federal government. And crucially, the Senate bill says, quote, no court may consider any factor other than the value of the costs and damages sustained, end quote. And he says that that could mean that they can't consider the potential damages to the plaintiff from the government's actions, nor could they consider the plaintiff's ability to pay. Further, he says requiring potentially massive bonds to enjoin government action could prevent many or even most such lawsuits from even being filed in the first place because few would have the means to pay up front. And this is especially true in cases involving sweeping policies where the government could claim costs into the billions. He says that only state governments could conceivably post bonds in that amount, though they would also balk at the potential hit to their budget. This means that many parties would have no choice but to accept a violation of their rights rather than to seek legal redress, severely undermining the Constitution. Now, as Justice Bullock explains further in the letter, this Senate provision is really actually worse than the previous House version, which targeted a judge's contempt powers, though we should still bear in mind the latter was also very bad and likely unconstitutional. However, if this provision, the one in the Senate bill, passes, the government could impose even blatantly illegal and unconstitutional policies for long periods of time, unless and until litigation reaches a final conclusion, which often takes years. And that could inflict grave harm on the victims of illegality. So consider, for example, a media who was subject to illegal censorship during a crucial news cycle, or illegally deported immigrants, or people who are imprisoned without due process. Right now, Republicans are seeking to enact these restrictions in order to block injunctions that constrain this GOP administration's policies. But it is very important to understand that under a more left-wing administration, this very same tool could easily be turned against the rights that conservatives value. Just consider for a moment a left-wing president who decides to target gun rights or religious liberty, or tries to censor speech because some DEI activist considers it offensive. Now, ultimately, we should all be able to agree that it is more important to ensure the vast powers of the federal government cannot be used to undermine the Constitution and take away our rights than to ensure an administration can swiftly implement all preferred policies, regardless of legality and constitutionality. And bear in mind, too, that if a rogue district court did try to impose an injunction improperly, which means without having someone first post this bond, a higher court could very quickly stay and overturn that decision, as has happened a number of times in recent months. So, if this Senate provision gets enacted, there is a chance that the courts might invalidate it as unconstitutional and an assault on the power of judicial review, which it is. But it would obviously be better if Congress simply did not go down this dangerous road in the first place. Now, I also want to highlight a letter that was sent yesterday by a coalition of major, mostly libertarian and conservative public interest group who submitted this letter to the Senate opposing this provision and urging Congress to reject it. Now, among the coalition of public interest groups who took part in the writing and sending of this letter include the Firearms Policy Coalition, who were actually sort of the prime movers and central organizers of this letter, but also the Institute for Justice, the Foundation for Individual Rights and Expression, the Goldwater Institute, and the Liberty Justice Center, and some others too. But here is an excerpt from their letter. So they say, we write as a coalition of organizations who rely on the federal judiciary to uphold constitutionally protected rights and serve as a check on unlawful government action. We are gravely concerned about a proposed provision in the Senate Judiciary Committee's language of the reconciliation package, specifically Subtitle B, Section 203 of H.R. 1, the One Big Beautiful Bill Act, that, if enacted, would mandate that courts require security in order to issue a temporary restraining order or preliminary injunction against the federal government, effectively shutting down access to justice for most Americans. We are talking here about upwards of millions, if not billions of dollars that could be required up front, effectively shutting off people's ability to enjoin the federal government from causing them irreparable harm. Now, this letter went on to point out a very important fact, and they say this is not a partisan issue. It's a direct threat to constitutional accountability. If enacted, this provision could seriously impair meritorious public interest litigation across the board, no matter the issue or ideology. The substance of a claim wouldn't matter. What would matter is whether the plaintiff could afford to pay. Access to justice would hinge on wealth and not merit, leaving Americans of all political stripes without recourse when their rights are violated. But they say under this provision, a plaintiff's ability to obtain that critical protection would depend not on the merits of their case, but their ability to pay an astronomical bond up front. They point out this is not legal reform. This is a financial blockade on constitutional accountability. It rigs the system in favor of unchecked federal power, and it sends a chilling message. Unless you're wealthy, don't bother trying to protect your rights. Now, if this provision is enacted, it will not matter what political party is in power. Its impact will be felt by everyone, whether the issue is freedom of speech, or religious liberty, or gun rights, or due process, or any other fundamental freedom. This kind of legal barrier puts all of those fundamental rights at risk in a real sort of heads I win, tails you lose framework, which always sees the federal government coming out on top. The fact is, no government should be allowed to insulate itself from judicial review by making it prohibitively expensive for Americans to petition the government for redress and seek to protect their rights through restraining orders and preliminary injunctions, which are often the last line of defense before suffering irreparable harm. Now, the fact is, this provision creates a perverse incentive for government officials to actually increase the scale of their illegal policies. The larger the scale, the higher the potential that the costs suffered by the government if it is unable to immediately implement them. So, challenging the illegal detention of thousands of people would require a much bigger bond than challenging that of one or a few people. And challenging the illegal seizure of a large amount of property would require a larger bond than challenging that of a small amount of property, and so on. Now, the one small ray of hope is that this provision may be ruled out of order because it violates what is known as the Byrd Rule. And this is a restriction on the range of policies that can be enacted through reconciliation bills like this one, which bypasses the Senate filibuster. Now, if it is not ruled out of order, uh, then Congress should still simply strip this unjust and dangerous policy from the bill. Well, that is all I have for you guys here today on Legalese. Thank you so much for tuning in. If you would please take a moment and do all of those things that help to trigger Al Gore's rhythm, I would greatly appreciate it. If you liked the video, hit that like button. If you disliked it and you want to be a dick about it, you can hit the dislike button. Hit the subscribe button to make sure you always get notifications whenever I post new content here on YouTube. And don't forget to leave me a comment. Let me know what you thought about the video. And also, of course, go head over to legaleseshow.com where you can find all of my content, not just my videos, but podcasts and articles. And also subscribe to my newsletter and get notifications about all new content sent right to you. So until next time, this has been Bob for Legalese talking about the big, beautiful bill. And of course, as always, Carthago delenda est.